Good morning, everyone. It is Thursday, um, October 15th, and it's time for the Thursday morning live stream. I am Mitch Beinhacker. I'm a business attorney in Clark, New Jersey. I draft all the agreements and handle all the transactions that you need to run your business, sell your business, and grow your business. Today I'm going to talk about, I've been getting some questions, had some calls with some clients and some colleagues from out of state about when designing your estate plan, should you be avoiding probate using revocable trusts? And things vary from state to state. New Jersey is very different than some of the local states. And I thought it's important to talk about it. And then at the end, I'm going to get into a little bit about what's going on with the practice rating, some new services that may be helpful to people listening out there. So probate. Probate is the process of filing your will with the surrogate court, with the court in the county in which you live or passed away, your person passed away. As the executor, you're the person who was appointed under the will to file the documents, file the probate, and transfer assets, appoint guardians, appoint trustees, dispose of assets, notify the beneficiaries, all those types of things. If you die without a will, it's called dying intestate. You go through a process called administration. And if you're appointed, you're the administrator. So same process, just no will. And the way your assets are distributed is based on state law. So it's important to know that if you don't have a will, how the state law affects where your assets are going to go. Generally, it's not the best option. It's usually an option of default because somebody didn't draft a will and didn't take care of their affairs. Can be dealt with, is more costly and more involved than having a will. Okay, so the probate process, a lot of people read about probate, and there's always this issue about that probate can be a costly process. There's court appearances, there's legal fees involved. The attorney's got to handle some stuff, final tax returns, and maybe an inheritance tax return along with an income tax return, all those types of things. In New Jersey, unlike other states like Florida, California, New York, the probate process is not a complicated process. It's not an involved process, and it's generally not a costly process. Okay, so you may see seminars, for example, being run by other attorneys, none of them are which are my colleagues, but running seminars for older people to set up trusts to avoid probate. So in Florida, for example, because I have a fair amount of relatives in Florida and a lot of colleagues down there, what they do on the estate planning side is they set up a trust, what's called a revocable living trust. So you can cancel it at any time. You can take assets out of it at any time. You're the trustee. The tax identification number of the trust is your social security number. But the trust in and of itself is almost like a company that will continue to exist after you die. So any assets that you put in the trust, and in those states, you would move most of your assets into the trust. Your will would simply be what's called a pour over will. It says, listen, whatever I have left, just dump it into the trust. All the provisions of your estate and who gets assets at your death and how are they managed are all in the trust document. You may have a joint document with your spouse. You may have separate trust documents. You have to retitle all your assets, retitle your bank accounts, set up new bank accounts, and so forth. So it's involved. Fees for these types of arrangements can run $7,000 to $10,000 in some cases. I am speaking in New Jersey in this area, not necessarily in Florida, but I'm sure they're not cheap down there either because it's involved. There's a lot of work for the attorney to do. What that does is avoid probate. Any of the assets that are in the trust will not go through the probate process, do not have to be retitled, and do not have to be dealt with by the courts. In states like Florida and New York, the probate process is more involved. There's opening of the estate, there's appearances by the attorney, there's filings, things that can run up the cost of a probate that could be $10, $20, $30, $50,000 of an estate that may not be that large to begin with. And a lot of the people who live in those states are told by lawyers that if you do this, you'll save money on probate. You also won't tie up assets in the process. So if you're waiting on tax clearances or you have a hearing or somebody contests or things like that, assets can get tied up in court. They're harder to contest if they're in a trust because you'd have to bring an action against the trust. There's no forum where the will's filed and you can contest the will because you can contest, but there's not much in the estate. But the real reason that people generally set up revocable trusts and set up their assets to avoid probate, and I'm going to talk a little bit about titling of property in a minute, is the cost, for the cost savings, because they believe it's going to cost a lot of money to have their estate probated, and in some states that's true. New Jersey, that is not true. In most cases, you can fax the will along with an information sheet to the courthouse. They'll call you, email you, text you, whatever, and say, okay, everything's ready. Come down, write us a check, and we'll give you your forms, and you can be off and transferring assets and so forth. Now, it's a little bit more involved now because of coronavirus, but things are done through the mail. You might need an attorney to get things notarized and so forth, and then sent back. But COVID aside, it's really not very involved, and the surrogate's offices tend to be very helpful because they're dealing with grieving people. They're not dealing with people that are litigating. So now, having said that, there are other ways to avoid probate besides a trust. If any asset has its own beneficiary or certain titling, it will avoid probate. So the life insurance policies in general have a beneficiary. If there is no beneficiary, it would go to the estate, and then it would go through probate. But if your spouse is the beneficiary, if your children are the beneficiaries, it would avoid probate. If you have beneficiaries on your IRAs or other retirement accounts, those will avoid probate. If your property, if you have real estate or your home is titled joint with rights of survivorship between husband and wife, it's tenants by the entirety, but it's a joint with rights of survivorship designation. When you pass away, that property will automatically pass to your surviving spouse, and they don't need to go to probate. You may have to file a new deed to clean up the title, but no probate. You can pay on death designations with a lot of accounts, securities accounts, bank accounts on file with financial institutions, also avoid probate. So there actually are ways to have a lot of your assets avoid probate and the cost of probate if that's something you're concerned about. So I just caution people to stay away from these seminars where they're showing all these great ways where they set up these trusts and your life's going to be simple and it's going to be real easy. And you end up writing some big checks that you probably don't have to. So, if you're doing a will package, husband and wife, that's not too complicated. With me, it'd be $2,500 or so. And for a revocable trust arrangement, it's going to be $5,000, $7,000, $10,000. So it may not be necessary. And I would get outside advice and counsel on that before you do anything like that. There are some reasons for using revocable trusts, privacy reasons. Maybe you do have a situation where somebody can't really manage their affairs, and it's easier to put the assets in trust and then have you manage, different trustee, have you manage the assets. There are reasons where if for some reason, because of the makeup of the estate, you don't want the assets to be tied up even for a little while in probate, a trust would avoid that. In some cases, you have to get certain waivers from the court in order to get assets released if they're in a bank account. So that would avoid that, but it doesn't necessarily save money. So you got to, weigh the costs and the benefits of doing that. So with regard to any of the ways you want to set up your estate, you can do it without a trust. You can do it, like I said, changing the beneficiaries of accounts and the titling of accounts and so forth. And I've seen people do it. Or you can do it with a trust. Without a trust, your assets would go through probate. You're still going to have to file final income tax returns, potentially inheritance tax returns, depending on who you're leaving your assets to. You don't avoid that with a trust. You also don't avoid any taxes that may have to be paid. So if property is left to certain beneficiaries, there may be inheritance taxes. If there happens to be an estate tax in New Jersey or at the federal level, right now there's not for most Americans, but that may change with new administrations and changes in laws. So if there is, it's all included in your estate. That includes any other asset that you own that has a beneficiary designation. So life insurance, if you own the policy when you die, is included in your estate. Retirement accounts are included in your estate, although there may be a deduction for income taxes paid on the account. You don't pay double, but you do pay a little bit of both. And so that it's not a tax planning mechanism. It's also not a creditor protection, asset protection mechanism. A revocable living trust is as if you own the asset. So you don't really have any protection in that regard. So if anybody has any questions about probate, they're having a discussion, they read an article, just send me an email and I'll be happy to have a short discussion with you about it. But that's generally the case with regard to revocable living trusts and probate in New Jersey. Little information with what's going on with my practice. So we are implementing a new system. Actually, we've had the new system, but are rolling it out to more customers. We use an online vault and are setting up a maintenance program for estate planning customers as well as family-owned businesses and business customers. So I think I've spoken weeks about it, and there was several emails that rolled out. We have a monthly retainer program, outside general counsel for your firm, for your company. So if you're a small business owner, your family-owned business, multifamily-owned business, an executive professional that wants regular representation, we generally like to work on a flat monthly fee plus discounts if other work's needed to stay on top of all of your affairs and help you with everything. As part of that, all of those customers who pay a monthly fee are receiving a membership in our online DocuBank document vault. It's a secure encrypted vault where you can keep all of your personal documents, all of your business documents. So for estate planning clients, the husband and wife or spouses can obtain the service on an estate planning basis. It's a $500 setup, which includes a 5-year membership in the DocuBank service, as well as there's a monthly fee of about, I think it's $49.99 a month, which entitles you to one annual review. We'll do a 30 to 60-minute call to review your estate to see if anything needs to be changed, as well as if you're on that program, any future work, if you need to update your will, if you need to add a trust, will be done at a 50% discount, half off of what our then normal rates are. So if you're interested in that, there'll be a link in the show notes. You sign up online and then we'll set up a call and get you started and get your vault set up, and we'll maintain the vault. I think individuals, it's $350 set up and $29.99 a month, and couples are $500 set up with $49.99 a month. And the monthly packages for business owners includes that service. So I have a lot of people that call me, and which is the reason why we're rolling out this service, and they can't find half of the things that they need me to look at. They can't find deeds, or if they find it, they can't find all the pages, and they can't find business agreements. They can't find insurance policy. They have to call their insurance advisor. They don't have access to their tax return, so they got to call their CPAs. Well, part of that will be, we'll have you sign an authorization letter for your CPA and for your insurance advisor to make sure they send us electronic copies of your tax returns. We'll keep 3 years of tax returns. We'll keep current policies. We'll keep deeds. We'll keep trusts. We'll keep wills, any business agreements, formation documents, and it'll be a good repository for your personal documents. So you'll have access to that, and we'll have access to that. You can upload things to that I can't even see if you choose to do so. That'll be a feature. As part of the service, it includes an emergency access wallet card that makes your healthcare directives available to a medical doctor, a medical professional, or a healthcare facility, whereby if you have a car accident and you go into a hospital, or you're going in for treatment and you don't have your living will with you, your healthcare directive, because we don't walk around with them in our purse or our pocket, this card has a website or an 800 number where they can call, have it faxed or emailed to them, and get a hold of your healthcare directive. It also includes emergency contacts that will be notified if that card is activated, as well as a physician if you want to put down. You can do list of medications, any other instructions. So that's included in that service. You can also add, there are cards for college children, adult college students. There's a card for adult children with special needs. And there's additional fees, but you can purchase it for them as well. And there's emergency access information. So it's a very good service. We've been using it for a long time on a one-off basis, but now we're rolling it out to the whole practice and to people. So if you do have the DocuBank card for your children, for you and your spouse, you'll be contacted by me in the future, probably by email, to see if you want to enroll in the estate plan maintenance service. But it's a good way to stay on top of everything at a reasonable cost to review stuff every year, because usually what happens is you wait till some event happens in your life and then you have to go back and dig through all of your stuff. So it's a good way to stay organized. Thank you, everybody, for listening. Today is the 15th of October. This has been the Thursday morning live stream. I'm Mitch Beinhacker. I'm an attorney, Beinhacker Law in Clark, New Jersey. If you want to learn more about my practice, you can go to beinhackerlaw.com. You can text law to 21,000 to receive my digital business card. And I hope you always listen to me interviewing interesting business owners and social media influencers and authors and other people on the Accidental Entrepreneur podcast, available on Apple, Google, Amazon, Spotify, Stitcher, and iHeartRadio. Videos are also available on YouTube. Thanks for listening, and enjoy the rest of the week, and have a good weekend.